Okay, we all ready? Ms. Tomasi? I think you're muted, Ms. Tomasi.
Thank you, Your Honor. Good morning.
Good morning.
May it please the court, my name is Marie Tomasi. Thanks to Zoom, I guess that's even more obvious. With me is my partner, Greg Hutt. We're from the law firm of Trenum Law, and we represent the appellants. I would like 5 minutes for rebuttal, please, Your Honor.
Okay.
This appeal presents essentially one issue for review, and that is the trial court's erroneous determination based on a sentence in one paragraph and a typographical error in another, that there was a reasonable ambiguity sufficient to prevent the city from making an informed decision whether to accept a proposal for settlement presented by the appellants. This court has de novo review and must reverse, because when read as a whole, as written, without nitpicking or searching for an ambiguity to prevent an award of fees against the city, and when read in the context of the rule 1.442 and the statute 768.79, the proposal was not sufficiently ambiguous to render the city unable to decide. The preamble to the proposal starts by saying the proposal is being made to settle all claims in the action. Paragraph 3's second sentence of the proposal says, this proposal resolves all damages that would otherwise be awarded in a final judgment in the action.
Ms. Tomasi, yes, and the proposal, while it said that it was to settle all claims, it specifically set out counts 1 through 4, and it did not include count 5. And looking at count 5, that's an indemnity claim, correct? And so couldn't that claim have proceeded independently of counts 1 and 4? Isn't that really the ambiguity here?
Your Honor, I'm sorry, the screen froze in the, we need Brian. Your screen, my screen froze in the middle of your question.
Okay, I'll repeat it.
I hate to ask you to repeat it.
That's good. Maybe it'll get better the second time. So let me try it again. So
it said, I'm sorry, Your Honor, my technical assistant is here now because it said on the screen that my internet connection was unstable. So I just waved him in case we need to do anything about that.
Okay. Do you want me to go ahead and repeat? Okay. My question is the proposal says, and I believe it's the same in each of the proposals that were sent, that it is to resolve all claims. However, it references the second amended complaint, then it references the third amended complaint. And when it does so, it talks about only counts 1 through 4 of the third amended complaint, which had 5 total counts. And so my question is, isn't the reasonable ambiguity here that count 5 is an indemnity claim and could proceed independently of counts 1 through 4?
Thank you, Your Honor. I very much appreciate your repeating that so I could get the entirety of what you asked. So the paragraph at issue, paragraph 3, does in fact say in the first sentence that the proposal is made to resolve all claims by the city against the appellant in counts 1, 2, 3, and 4 of the city's third amended complaint. And the second sentence says this proposal resolves all damages that would otherwise be awarded in a final judgment in this action. Those sentences are not in conflict with each other. They don't have a disjointer. It doesn't say or but. And so really what the question I think boiled down to is, was it required to say end count 5 when you read this provision or this paragraph in the document as a whole? And that's really the crux of the matter.
But when you combine that paragraph 3 language with the paragraph 7 language, which references the second amended complaint, why isn't it ambiguous and confusing as to whether or not count 5 is included in the offer or whether it is not? Because first of all, it isn't specifically identified along with the others in the third paragraph. And then it kind of enhances the problem by what the language of paragraph 7 that references a second amended complaint, which doesn't even have a count 5 in it.
Well, Your Honor, there's, I guess these two questions really that you're both asking are interrelated. And there's several problems with the conclusion that it leads to a reasonable ambiguity. One is that, excuse me, that you can't read, that the case law is pretty clear. You can't read a paragraph or a typographical error in isolation, but you have to read it in the context of the whole document. Another challenge to this idea that absent identifying count 5, the city wouldn't know that it was included is totally negated when you read the document as a whole, because the proposal starts by saying it's to resolve the whole action. It, in paragraph 7, requires the dismissal of the action with prejudice and the execution of a general release. And the general release releases all claims arising out of the allegations of the third amended complaint. So these provisions all make clear that this case was to resolve all of the claims. There is a case out there called Russell Post out of the 3rd District that has a similarity that I think is directly relevant to the point, where the plaintiff was saying, I just want to lay my hands right on that. The plaintiff was saying that she couldn't know the full scope of a release that was required by the proposal because the release wasn't attached. And that this created an ambiguity. And the court found that any reasonable doubt that the plaintiff might have had was, quote, fully and finally dispatched by the requirement for the plaintiff to dismiss with prejudice all claims. So here, let me say, assume, which we dispute, and I'll talk about that more in just a minute, but let's assume that the city actually had some reasonable doubt about whether count 5 was included when it read paragraph 3, and even with the typographical error maybe being involved, when you read the document as a whole, it becomes clear, and it contains that requirement to dismiss with prejudice all claims. When it says to dismiss with prejudice its action, the city couldn't dismiss its action without dismissing count 5. The city couldn't sign that general release that was attached to the proposal without releasing count 5. Another illustrative case that you might want to know about is the MGR case from 1999. It's a Florida Supreme Court case cited in the briefs. That case was looking at the statute 768.79 and said in that case, I'm sorry, I've completely lost my place here, that the failure to mention counterclaim was not rendering the offer or the proposal unenforceable. It didn't mention it at all because 768.79 subsection 2 requires offers to be construed as including all damages that could be awarded in a final judgment. And so just like here where we are arguing, now the rule has also been amended. This court addressed that in the Bright House decision in 2018. the rule was amended effective 2014 to also require the resolution of all damages that could be awarded in a final judgment. And so now you have both the rule and the statute making that requirement. So just like in MGR, where the offeror did not have to mention the counterclaim, our clients, the appellants, were not required to mention count 5. And if you just, I think it was as the 4th District called it in the Alamo case, it's mildly seductive, I believe is how the court put it, to read a sentence that's poorly written and maybe even confusing and say it's ambiguous, but it's substantively wrong, because you have to read that sentence in the context of the whole document. Well, much like that, we submit here that if you read from the start to the end of this document, including the release that's attached and all the provisions, it is not unclear that all claims will be dismissed with prejudice and all claims raised in the 3rd amended complaint will be released. Your Honor, I think, Judge Smith, that you asked, what about the count 5 standing on its own? That is a fallacy. And I don't know, not you, the trial court's conclusion on that. And I don't know where and how the court got to that analysis, because first of all, if the city settled counts 1 through 4, that's the breach of contract and the 3 negligence counts. Those were the basis of count 5, the indemnity claim. So when you settle claims by accepting money and you give a release, you've released those claims. So there's no way that the city could have still had an indemnity claim, because it wouldn't have had anything on which to base the claim for indemnity, because it would have settled them. Also, the trial court sort of, I'm going to say oddly, equated a settlement with a concession of liability, which is, we all know, not correct. Parties settle without conceding liability. And in fact, paragraph 6 of the proposal for settlement expressly says that the proposal is made and can be accepted with no admission of liability. And so I think the trial judge just had a little bit of a skewed view about this.
Ms. Tomasi?
Yes, sir.
State Farm Mutual Auto Insurance versus Nichols, which is a Florida Supreme Court decision in 2006, basically indicates that a proposal should be capable of execution without the need for judicial interpretation. So what we're here now is having a very spirited debate about whether this is nitpicking or whether or not basically it was a substantive error and therefore ambiguous. So we are, the trial court, engaged in judicial interpretation of this to try to figure out which it was. We are now, of course, in the process of engaging in judicial interpretation to figure out what it was. Doesn't it ipso facto mean that it's ambiguous by the very fact that we are here arguing about it?
No, Your Honor, respectfully, I would disagree with that. I think that parties all the time go to court and argue with each other over things that are not actually in dispute or not actually reasonably disputed. And I think what's happened here is the city rejected the offer. The city went to trial expecting to do a lot better. They did not. And then they figured out a way to avoid getting attorney's fees awarded against the city by claiming this ambiguity. The city knew the 2nd amended complaint had been dismissed. That was not a surprise. The city knew the 3rd amended complaint was the operative complaint at the time the proposal was made. The release and the rest of paragraph 7, dismissal with prejudice, is very clearly read to resolve the whole case. And the reference to the 2nd amended complaint really there's one reference in the whole document, was just a typographical error, plain and simple. And there are several cases that we cite in our brief that talk about how a typographical error does not create an ambiguity when it can be, when reading the entirety of the proposal explains what's happening. And so, for example, in one case, the release had names of strangers to the action in the release, completely unrelated. And the court said that's not a reasonable ambiguity because you can read the rest of the proposal and understand what's being offered. That's clearly just a typographical error.
You're at 15 minutes, just so you know.
Oh.
Use your time as you choose.
Well, that just goes so fast. Thank you so much for letting me know. I will just very quickly say that we believe that when you read the proposal as a whole and you include all the provisions that require the resolution of all claims, the dismissal of the action with prejudice, and the release of all claims, and you avoid reading one provision in isolation or any paragraph or phrase in isolation, but instead interpret it as a whole, like the Alamo case, like the Allen court said, the Florida Supreme Court, like the Kiefer decision, and you read it in the context of the rule and the statute, which required that these proposals resolve all claims, and in light of all the other provisions of the proposal, that it was not a reasonable ambiguity and should not have prevented enforcement of the proposal after the result of the trial. I would very much like to reserve the rest of my time, please.
You will have 3.5 minutes when you come back.
Okay,
All right.
Thank you.
Mr. Shannon, you're up.
Thank you, Your Honor. May it please the court. My name is Nick Shanine of the Shanine Law Firm, and together with John Lamole of the law firm of Tannenbaum Scrow, he's off screen, we represent the city of Sarasota, the appellee. Your Honors, the trial court got it right. The trial court listened to hours of argument, going to Judge Morris's point that there are definitely issues for which judicial interpretation for this particular proposal was required. Because if this were a 10-minute hearing, that might be otherwise, but this wasn't. There was hours of argument, multiple briefs, documents filed with the court. The court had been the court that had presided over the 5-week trial. So the trial court was intimately familiar with the legal issues and the differences between these various complaint iterations and the counts. And at the conclusion of that, the court properly assessed it all, put a really well put together order. That this isn't a quick order that just says fees are denied. It goes through the analysis. And when it goes through the analysis, it starts with the construct that the court is not to nitpick and the court is not to infer ambiguity. But here, the court recognized you don't have to do either. There is no nitpicking to be done. There is no inferring ambiguity. The ambiguity is patently on the document. And this goes to Judge Smith's question that, counsel tries to jump straight to, well, first they start in the preamble, which isn't even something that 1442 discusses. The particularity requirement that the Supreme Court in Nichols and Allen and all the other cases have continued to require is that each of the particular elements of 1.442 must be stated with particularity. And so when doing that, the count that's titled claims to be settled, that's the big heading, claims to be settled. The sentence that follows that is this proposal is made to resolve all claims made by the city against AECOM in counts 1, 2, 3, and 4 of the city's third amended complaint. Obviously, to anyone who sees the third amended complaint, omitting count 5. That sentence cannot, it is a patent ambiguity for that sentence to then be followed by a sentence that says it resolves all damages. Those two sentences don't make sense. But then going to Judge Black's point in his question to Ms. Tomasi, and that was, well, isn't that enlarged, or as the trial court said, exacerbated by paragraph 7? And the answer is it absolutely is. That count 7 discusses all claims in the second amended complaint. Well, why refer to a prior version of the complaint? And if you're trying to interpret this particular proposal the way it's drafted, the answer is this: the second amended complaint matched perfectly with what they described in the first sentence of paragraph 3. The second amended complaint has counts 1, 2, 3, and 4, and it does not have a count 5. So
But
those,
Mr. Shannon, but Mr. Shanine, excuse me, Shanine, is
You
it
do.
a reasonable ambiguity here though, where yes, the proposal and let's assume it's a typographical error, didn't include count 5, and it's another type, then I have to assume it's another typographical error because of the second amended reference. But isn't any ambiguity put to rest by just reading the general release, which is attached to the proposal, where it doesn't include any counts and it simply says all, I think all, I'm paraphrasing, but it's something to the effect that it's all claims in the third amended complaint.
Sure. And the answer to your question, Your Honor, is no, it is not resolved by that. There are a number of cases, this court's Decidui case from 2017, South Florida Pool and Spa versus Sharp, third DCA from 2016, the Dowd versus Geico case, a number of other cases that talk about the release. And while a release is allowed to have some generalities that might not have been included in the settlement, you can't have a complete disjointer. You can't have a claims to be settled 1, 2, 3, and 4, and then a release that says, oh, and the kitchen sink too. Mr.
Shanine, the problem here, of course, is
right.
Everybody knows that there was a third amended complaint, and you can't put out a proposal for settlement to settle an earlier amended complaint when there is a subsequent one. So I just think common sense tells you that is an obvious mistake. There's really nothing to interpret about the second amended complaint.
And I would agree with that if that had been the only mistake. If that was
I'm just focusing on that issue. So while it doesn't help leaving out count 5, right, because the second amended complaint didn't include count 5, right, it clearly is a mistake, because we know, everybody knows, there is a third amended complaint. So the proposal for settlement would be ridiculous to try to resolve a earlier complaint. So, I kind of throw that out the door. I mean, I don't think that means anything.
I agree with Your Honor that it's not the reason why this case is resolved the way it is, which is that AECOM is not entitled to fees because of this ambiguous proposal. But the trial judge correctly described it as exacerbating. That's all. Well,
I think that Judge Smith's question has been the best one of all in this session, and that is, could count 5 travel on its own? And if count 5 could travel on its own, then we have something to talk about. If count 5 could not travel on its own, then we have nothing to talk about.
Well, and respectfully, I would say that we still do, but it can't. It can't be resolved on that, because count 5 could have been left in if that was the terms of a settlement. The trial court, the trial court got it absolutely correct when the trial court described how this case could have continued, where if parties can settle whatever they'd like, and if we resolve counts 1 through 4, but carve out count 5, and we allow, look, AECOM, we're not going to hit you for any of your negligence. And by the way, the jury came back with a 50% negligence finding against AECOM. So those were real counts as well. It happened to be the jury said, but we're not going to find any damages associated with that negligence. So they threw out everybody's counts. They threw out ours and AECOM's, and they diminished greatly the other party involved, Wester's counts too. The jury wasn't enamored with any of these parties. But the important part is that with those 4 counts, they could settle those. We could have said, AECOM, you're right, we will accept your money, and in return, we won't hold you liable for your own direct negligence or your contractual breach. But if this other party hits us because of any of these things, we can still proceed with that. And as long as the parties have settled only those claims and not this 5th count, then absolutely, that's the way it would go. That while opposing counsel tries to argue that hey, the judge over empowered this by saying it was an admission of liability. Neither would the settlement be be something that would remove liability. It wouldn't be summary judgment. And here's the really critical part, Judge Morris. This goes to your question that you asked earlier, and that is that State Farm v. Nichols and every case, including Allen v. Nunes that follows, makes it clear that the city of Sarasota can't be required to make a call which would require judicial interpretation. Whether or not count 5 can stand on its own is clearly a matter that requires judicial interpretation. If this settlement had gone where they resolved counts 1 through 4, and then they said, aha, we actually tricked you, and now we're going to move for summary judgment on count 5, well, that would be a matter that obviously would have been hotly contested, would have required judicial resolution, heck, would have probably involved an appeal had that particular set of dominoes fallen in that way. That there is no question that this proposal, as it was phrased, with 2 different sentences containing ambiguity, and in particular, the one sentence being under the phrase claims to be settled, and then they list the 4 claims and specifically, or so it would appear, exclude the 5th. That's not a typo. And I do want to go back to that. A typo would be, the wrong name of a party thrown in, or a gender gets switched is one of the other ones that the opposing brief has. It cannot be a typo. And the reason I say that is that the sentence that they're arguing they intended, they wrote, this proposal resolves all damages. The sentence that they preceded that with, the big sentence, can't be a typo, because why are they spelling out claims? Why are they spelling out which counts it dismisses? This proposal is made to resolve all claims made by the city in counts 1, 2, 3, and 4. They don't need to say that sentence at all. You would have to decide the entire sentence is a typo, and the decision to put it in there was accidental, and they didn't even argue that. They didn't try to argue that below. They're not arguing that here. They intended to include the sentence, but if you intend to include that sentence, why? The rule that they refer to specifically says, here's the sentence you should put in. They did not. They put in this other sentence. They are the ones that injected this ambiguity into this release, into this proposal for settlement. Did it create a reasonable ambiguity? Absolutely. And the trial court could not have synthesized this better. There are legions of cases where it's a clear ambiguity. There are legions of cases where it's nitpicking and the court says throw it out. This is not nitpicking. This is not a inferred ambiguity that you kind of say, well, did you dismiss the claims that should have been brought by somebody else at another point? No. This is the claims that were active in the complaint, the 3rd amended complaint, when it says counts 1, 2, 3, and 4. This court in Tran v. Anvil made it clear that the rule must be applied strictly. The Florida Supreme Court, when it referenced Tran, did so saying that Tran's good law, and it intoned again in Allen v. Nunes that proposals under the offer of judgment statute must strictly conform to these statutory and procedural requirements to entitle the offer because the statute is in derogation of the common law that ordinarily requires each party to pay for its own attorney's fees. This court has been very strong on the American rule. Topoli versus Feliciano was a decision by this court just last year that laid out why the American rule is what it is, and that each party pays for its own fees unless a specific statute or contract is in derogation of that common law that can be applied here. The rule 1.442 absolutely requires strict compliance. That strict compliance said, if you don't do this, you just say all damages and you're done. They didn't do that. What they did is they made it a patent ambiguity. The court didn't have to search for it. We didn't have to search for it. It was right there. Whether or not they included a typo in their 7th paragraph that happened to perfectly sync up with that, that typo, if it were, that's not what rises or sinks this ship. It simply gives further ballast to why this ship is going down. So for each of these reasons, Your Honor, it would be consistent with this court's well settled decisions in Tran and Decidui. It would be consistent with the Florida Supreme Court's decisions. The construct of expressio unis est exclusion alteris, when you have a list of things and you don't include one, we all know what that means. The things that you said are included, the thing that you didn't is not. And while they would like to say, well, but then you got to look at the next sentence, but that sentence right there says what it says. And if the next sentence says something different, they don't get to cherry pick which sentences are, well, if you look at the document as a whole, the trial court looked at the document as a whole. In fact, I'm going to conclude with the trial court's closing paragraph because it sums it up. It really does. Even reading the proposals as wholes in their entireties, there is a reasonable ambiguity as to whether the settlement proposal included on count 5 is included in all claims to be resolved. The city's confusion over count 5 is reasonable based on ambiguities in the settlement proposals that required no nitpicking to find. The court did not need to engage in nitpicking. The court didn't need to search for ambiguities, didn't need to infer an ambiguity. The ambiguity was right here. And for each of these reasons, Appalachia City of Sarasota respectfully requests this court to affirm. Thank you.
Thank you. Ms. Tomasi? Oh, you're muted again. Yeah.
This
Okay,
is not the first time in my Zoom life that
Well,
I
you're
have
there.
done. Thank you. Thank you, Your Honor. So I'll be very brief. I just want to hit a few points. First of all, this is not the first time that this has happened. Counsel for the city cannot explain how on earth count 5 could survive. If you look at the third amended complaint, just in the record, count 5 is based entirely on the allegations of 1 through 4. If 1 through 4 was resolved, count 5 could not stand. There's not a way that it could stand. The city didn't need a judge to tell them that. They made up that complaint. They know what they alleged for their indemnity. And so that is a very critical point. And we would invite the court to look at the third amended complaint and test me on that about counts 1 through 4 being almost the identical allegations of those counts being the allegations of the indemnity count. The other problem with that argument for them is that you can't settle counts. The proposal for settlement rule and statute both require that you resolve all damages that could be awarded in a final judgment in the action, not in some of the action, not in whatever you're trying to settle. And we go back to the fact that any doubt that the city might have had about whether count 5 was included is completely dispatched and resolved by the requirement of a dismissal with prejudice of its action. That's everything. And the release language that, as Judge Smith noted, releases all claims, paraphrasing here, leaving out all the rest of that language, arising out of the allegations of the third amended complaint. This idea of an ambiguity in the 2 sentences in paragraph 3 is also really where the search for an ambiguity took root, because the first sentence says counts 1 through 4 are being resolved, and the second sentence says all damages that could be awarded in a final judgment in this action are being resolved. It doesn't say or in between those sentences, but that's how it's read to reach the conclusion that the trial court read. I could say to my partner Greg here, I'll bring the apples and bananas to your party, period. I'll bring all the fruit, period. Is he reasonably in doubt as to whether I'm still bringing the apples and bananas because I said I'm bringing all the fruit? No, only if he inserts in between my 2 sentences an or, and then he might say, what? Is she still bringing the apples and bananas now that she said, or I'll bring all the fruit? But I didn't say that. Enforce it the way it's written, not the way that the court read it. And that's what we're asking. We believe that when you do that, when you read it as a whole from start to finish, it's very clear that the appellants were offering to resolve the entire action. The city rejected that offer because it wasn't enough money and they thought they'd do better at trial. They did not do better at trial. And then in the hunt for some way to avoid fees, claimed that they were confused when in fact they knew that the third amended complaint was the operative complaint.
Thank you. You're out of time, Ms. Tomasi.
I was afraid of that. Thank you so much. Appreciate it.
Counsel, both of you, your briefs were excellent. Your arguments were excellent. And this is a tough case, and we're grateful for the help you've given us on it. Okay, so have a good day.
Thank you, Your Honors.
Thank
Appreciate
you.
it.
Next case is Malonis versus